So I want to start off, not to bore everyone, but with a little bit of the legal framework in Canada, because I think it's important to understand the context in which we look at sponsored content and native advertising up north. Starting off with our Competition Act, antitrust statute that deals with representations made to the public. And I flag particularly representations made to the public. I'm going to come back in just a minute to what is advertising and whether that question really matters. Because here we've got a situation where the Bureau is regulating representations to the public, that what's prohibited is creating a false or misleading representation, something that's materially false or misleading. And when looking at the context of the representation, one has to take into account the general impression. What is the consumer, what is the reader taking away? Along with the legislative background, we've got the self-regulatory system. And in Canada, it's Canadian Advertising Standards Council, Code of Canadian Advertising Standards, regulated by Advertising Standards Canada. And for particular interest on this topic is clause number 2, which is no advertisement shall be presented in a format or style that conceals its commercial intent. We've had guidelines on advertorials for a long time. So really what's new here may be the medium, not the tactic, when we're talking about online, as opposed to it being in print or in other contexts. And again, I pause for a moment on what is an advertisement for the Canadian Advertising Standards Canada. Advertising is what counts. And there it's any message in any medium with the intent to influence a consumer's choice, opinion, or behavior. So again, what is advertising? When we're talking about native, when we're talking about sponsored content. From the consumer protection perspective under the Competition Bureau, or from the perspective of the code, if we've got a representation going out to the public and the consumer looking at that thinks that it is news, thinks that it's editorial, doesn't realize the commercial intent behind it, that's where we've got a problem. So whether or not it's advertising may not be a question really in terms of how it's labeled, how it's identified, except that the consumer needs to know that it's advertising, if it is, where the source of the speech is coming from. So from a Canadian perspective, what are we concerned about? Again, it's what is the consumer takeaway going to be on this message? So disclosing a material connection. Is this sponsored content? That should be disclosed in such a way that the individual seeing the content would know the nature of the communication, know what, if any, incentives went in behind its development, creation, or posting. And not to disguise the commercial intent. So in other words, transparency, an authentic communication. How do you do that in Canada? Well, our regulators are a little bit behind the United States in this front. Basically, our Competition Bureau, various members of the Bureau have told me that they keep the FTC guidelines on their desks, but the Bureau themselves have not released their own guidelines. So really, I advise clients to look to the guidance here in the States that the FTC has put out on these topics. The other question asked all the time, so what's everybody doing? Are advertisers in Canada doing it? Well, it really depends. And I would say for the most part right now, we do not see general practice being transparency with respect to sponsored content or native advertising. And often I'm encouraging clients to follow the FTC, but not seeing it as being the norm. A lot of clients are willing to take the risk. That may be about to change. The Canadian Code of Advertising Standards is under review right now. There are amendments that have been put forward for public consultation, expected probably to go forward based on the comments that have come forward so far, but will not yet final. But the proposed revisions are going to include defining what is a material connection within advertising and excluding from advertising messages from which there's no commercial or no material connection. So in other words, identifying where there is a material connection, requiring that be disclosed, and then looking at other content expressly excluded from advertising. So if you do have the true editorial, the true opinion piece, that would not be captured within the definition. Along with this will be a new interpretation guideline dealing with testimonials, endorsements, and reviews. And the interpretation guidelines sit along with that voluntary code to set the framework in which the code should be read and set the framework in which the code would be enforced. And this is going to end up requiring disclosure of any material connection between the author and the advertiser in close proximity to the representation. And again, for examples and for additional guidance, they're recommending people look to the FTC guides. So the FTC guidelines are going to be the way of the future for Canada. In terms of how it works, practically speaking, if we look at this as guidance under the code, there's no ability to sue. The only authority the Advertising Standards Canada has is to say the ad is misleading, stop running it. So no financial penalties. But the Bureau takes into account, when looking at what is proper conduct, what the industry is doing. So we're expecting to see a sea change here, and it's only a matter of time, I think, until the Bureau picks up on starting to regulate this as well. Two quick examples of where we have seen activity and enforcement, although not specifically on native advertising and sponsored contests. I wanted to flag this case of astroturfing, fake customer reviews. In this instance, this was a case against Bell Canada, one of our leading telecom providers, and the employees were encouraged to post positive reviews on iTunes and on the Google Store about a new app that Bell had developed to make paying consumer bills easier. The activity was identified by management, it was shut down, it was stopped very early in the process. But nevertheless, a year later, the Competition Bureau came along and they reached a consent agreement, a settlement of the case for $1.25 million. A huge amount when one considers that the app was free. There was no volume of commerce flowing through this. So although not directly on point in terms of specifically native advertising or sponsored content, this idea of authenticity, of transparency, is obviously something that the Bureau is taking very seriously. So that's why I say just wait for that case on the native advertising or sponsored content to come through. And the one instance that I want to flag without stealing any thunder from colleagues in the US is this Kim Kardashian post, which some of you may be familiar with. Kim was tweeting about a morning sickness drug that had done wonders for her, didn't disclose that she was hired by the company. It was a Canadian company behind the drug here. Interestingly, both the FTC and the FDA in the US went after Kim for this, for failure to disclose. In Canada, apparently there was a warning letter sent by Health Canada to say, quietly, you shouldn't do this. But in Canada, the issue was any kind of advertising about a drug, a named drug, is prohibited to the public. You can advertise to doctors, but this kind of advertising can't be done to the public. So even before we got into issues of disclosures, of truth in advertising, of sponsored content, became an issue just based on the fact that for Canadians, you can't do this. So this example again just speaks to the global nature. She's an American in the States, but it's a Canadian company and her celebrity's carrying the day, but we've got issues with the regulated product that she's speaking about.